So last year, the New York DA's office indicted Donald Trump for the election interference of the 2016 election, uh, based on the legal fees and hush money, all of that. Well, while indicted, Donald Trump started attacking the judge and other people, and it prompted the judge to issue gag orders. Then he continued to violate the gag order, and that is more recently, in the recent days, as the trial has come closer and closer, the trial date, that he has uh, violated the gag order, and the DA's office notified the court. The court then set the ruling date for April 23rd. And since the time that the judge set the date for the violations that Alvin Bragg's office filed, the three violations, legal experts have said that Donald Trump continues to violate and has violated the gag order at least 9 times since the time that Judge Mershon set the date to rule on the three gag order violations that DA Bragg filed. Now, will Judge Mershon also rule on the 9 violations that DA Bragg has not filed? That is the question. Welcome to Law and Society. If you are new to my channel, please like and subscribe. And I want to ask this question so badly of, of the judge, is why did you decide to wait until the 23rd to rule on the motions that came before you about the gag order violations? The whole point of the gag order is to promptly deter the defendant from violating it and thereby compromising the case or the integrity of the case and the safety of all parties involved. So, what did the judge accomplish by waiting all these days and taking all this time to review the gag order violations that were filed? Will he, on his own, pick up the 9 other alleged violations, or does the DA have to file those again? Will DA Bragg file, motions for 9 more gag order violations? And because the judge is only ruling on it at one point in time, it will all amount to one contempt where he will be fined $1,000 for each of those times that he has violated it. Versus, had Judge Mershon ruled on the gag order when, at least a day or two after DA Bragg put in the request for it, he would have been fined for those 3 violations, and then he would have been put on notice that further violations would have resulted in incarceration or some sort of restrictive uh, custody that would involve him not being able to communicate with the public, because for a limited amount of time, because he's a criminal defendant who continues to violate his gag orders. So these 9 violations that legal experts have pointed out that DA Bragg still has not brought any motions for will be, if Judge Mershon were to rule on them at the same time, would give Donald Trump the leeway of avoiding incarceration or house arrest with no access to internet or something of that sort, no access to his phone. He can give rallies, but no use of his Truth Social account. That sort of and enforcement can be made. And I mean, that would be less intrusive than incarceration, because incarceration is definitely on the table. So if Judge Merchan does not rule on those other 9 alleged violations and does not fine Donald Trump for them, and it comes out later that DA Bragg chooses to again file for violations of those gag orders, 9 violations, at that time the judge will have the discretion to incarcerate or in some way limit Donald Trump's communication capabilities and his movement, because he's a criminal defendant violating gag order. So that's just Judge Merchan, and that's just the New York case, the New York 2016 election interference case. The federal jurisdiction has been even more, it's certain parts of it even more relaxed. In the judiciary, a month's time to process an appeal is considered expedient, 3 weeks. But Bush v. Gore and other cases that were important and time sensitive were decided within 2 days or 3 days. Whereas the Supreme Court in the immunity case set a relaxed schedule of about 50 or so days, or was it 40 or so days, between the time that they would take the petition, made the ruling that they were taking certiorari to the time that there would be oral arguments and then the judgment. An expedient ruling typically is 3 weeks for the federal judiciary, the appellate courts. And 3 weeks is just not promptly enough after the oral arguments, because they already gave Donald so much time, and there's been such a delay on an underlying criminal trial that should SCOTUS take even longer. It seems to me that SCOTUS is violating its own precedent and not giving the public their right to a speedy trial. So that, in some minds, that has already happened when the Supreme Court decided to take up the appeal. In my mind, that was a conservative move in order to see the merits of the claim of the immunity of a former POTUS from criminal prosecution. Now, they have no excuse after the oral arguments to wait for 3 weeks to issue an opinion that is a single issue appeal, and that has a very narrowly tailored question as written by the Supreme Court itself, saying whether and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. So that's a very narrow question, weird question, and disturbingly slanted towards Donald Trump, in Donald Trump's favor, but still a very narrow question of whether there is immunity or not. It shouldn't take more than a couple of days to decide that, because there is an underlying criminal trial that has been stopped since February 6th, when the case went up for appeal. It's a very important criminal trial. It's a federal criminal trial that alleges Donald Trump's criminal involvement and conspiracy to interfere in the 2020 election. The New York State case is about interference in the 2016 election, and the DC case is about election interference in the 2020 election. So the urgency should not be lost in the procedure of the federal judiciary to call 3 weeks an expedient ruling. No, they should do it as soon as they can, and preferably within the week of after having heard the oral arguments on the 25th. With that said, thank you so much for being here. Please like and subscribe. Thank you, Deb, for being here. I really appreciate it. And if you have any questions about this matter, this frustrating matter about how the judges are being too lenient and coddling Donald Trump and giving him, emboldening him to uh, the belief that he is special and above the law. You know, the truth is that Donald Trump is not above the law. And we are this week in a moment of truth to see whether the judiciary appreciates the seriousness of Donald Trump's attacks and whether the judiciary appreciates the importance of criminal cases on election interference to go forward in a speedy manner because the public has an interest in a speedy trial. Thank you very much, and I will talk to y'all soon. Do remember to like and subscribe. Oh, uh, thank you, Claire, Miss Charles, for being here. I'm logging off now. If you just arrived, please do scroll back 10 minutes or so, where I discuss the my little anger with the judiciary not appreciating the threat that Donald Trump poses to our republic and to the rule of law, and just taking their time in ruling certain rulings that need to be ruled upon promptly, and not promptly in the era of the horse and the buggy, but promptly in the era of the internet, where I am talking to you from across the world, and you're able to get to that information that I'm providing, and not having to wait 2.5 months for me to send it to you. And that's in my lifetime. You realize that the times have changed, and I wish the courts would understand the times they are changing. All right. Take care.